Hello and welcome to another edition of Canada Files. I'm Jim Deeks. Our guest this week is Brian Greenspan, probably the best known criminal lawyer in Canada and certainly one of the most respected litigators in the country. The list of famous clients on Brian's list over the past 40-some years reads like an international who's who. Not that Brian seeks them out, they just come to him. And it's not hard to understand why. Brian's knowledge and respect for the law is always worth listening to. Brian, thank you for joining us on Canada Files.
A pleasure to be here.
You know, I've always been intrigued by the fact that you chose criminal law and defense in spite of all the other disciplines that there are in the legal profession, which, if you'd chosen one of them, might have made you a lot wealthier than you are today, if perhaps not as well known. Why did you decide, and you and your brother as well, the late Eddie Greenspan, who was also a very prominent defense lawyer, why did you decide to spend a career defending people and organizations who have been accused of criminal activity?
Well, it's not quite that criminal law was genetic, but it came close to being that. It's certainly part and very much part of our family history. Our father came to Canada as an immigrant when he was 13. By the time he was 24, he had a BA in law from the University of Toronto and had started at Osgoode Hall. The war in 1939 interrupted that, and as a result, he never completed law school. But our library at home was filled with the biographies of the great criminal lawyers, Clarence Darrow, the great English barristers, and it was all litigation-oriented, but almost primarily criminal law-oriented. Our father passed away when we were children in 1957, and his legacy was our profession. I think that as well, what was part of our education as children and as we grew up was a social commitment and perhaps a slight bit of anti-authoritarianism, a slight bit of the state has the resources, the individual needs the defense, and we, without being overly romantic, we somehow found ourselves as the finger in the dike holding back the forces of the state in some fashion and trying to equalize and balance the system and for a criminal justice system to operate effectively, the accused must have effective representation. The state has the resources. The accused at least needs a strong voice in the system to attempt to get justice.
So aside from the influence of your father, who died when you were still a teenager.
No, I was 10.
You were 10 years old. But obviously he had an influence on you. But aside from him, was there a mentor along the way or someone in the law who inspired you to pursue that career?
Both Eddie and I were certainly influenced by the litigators that we watched, the great lawyers, G. Arthur Martin, Joseph Sedgwick, Charles Dubin, who were the generation that preceded us, J.J. Robinette. All of them had their roots in the criminal law, although some of them went on to other areas of litigation. They were rooted in the criminal justice system, and we watched with great respect, and we watched and hopefully learned something from their stories.
Brian, I know that you and probably every other defense lawyer in North America has been asked this question hundreds of times during their career, but how can you defend people that you know or certainly suspect are guilty of what they've been charged with?
Well, first of all, you seldom know, and certainly I've been asked the question at virtually every cocktail party I've been at in the last 45 years. But you seldom know, and if you do know, you have to understand that most people who accept guilt, admit guilt, or who are overwhelmingly guilty, in fact, plead guilty. And our function and our role becomes one of putting the other side to the court in terms of trying to mitigate sentence and what the outcome should be for their wrongdoing. But where it's a trial, not guilty, there is an overwhelming importance in our process of justice. The prosecution in Canada and the prosecution in every common law jurisdiction, including the United States, has got the task of proving guilt beyond a reasonable doubt. And that's just not a general theory. It's what makes the process work, because unless that burden is satisfied, the person is to be found not guilty and is to be free. And if you relent and permit that burden to be relaxed, we risk more wrongful convictions than we currently have, and we have too many as it is. So that the adversarial process, the process of trying to find the truth and find justice, is dependent upon a vigorous defense and proof beyond a reasonable doubt.
Have you ever won a case where your client was either fully acquitted or at least had his or her or their sentence either or punishment reduced substantially, where you know in your heart of hearts that perhaps the verdict wasn't fully deserved?
I think not, actually. I hope that doesn't surprise too many people, because first of all, punishment wouldn't have been fully deserved unless the system proved their guilt beyond a reasonable doubt, and obviously in the acquittal situation it didn't. Therefore, the system owes that person the opportunity to walk out the door free. That's what our justice system is about, not making mistakes, and if we're going to make mistakes, we err on the side of an acquittal, not on the side of a conviction, as we often do. That's one part of it. In terms of punishment, quite frankly, I find incarceration to be overly emphasized throughout most of the world, and particularly in the United States, which is the most overly incarcerated nation in not only in the common law world, but in any democratic country and in the free world. The United States uses incarceration as one of its primary tools. We in Canada are much more consistent with incarceration in Europe, where our statistics are very similar to France, Germany, and slightly below the United Kingdom. But the rate of incarceration in the United States exceeds our rate by 5 or 6 times.
So when a client does tell you the truth when you first interview them, do you then sometimes refuse to take the case knowing that there's really not a lot you can do for that person?
No, I don't think that's our role. It may well be that the strong recommendation is we can do better for you if you've now, if the truth is that in fact you're guilty of that offense or a lesser included offense, but you're guilty of some criminal act, then what we can do is try to negotiate a lesser offense, a mitigated sentence, something that will be helpful to the person in the long run. And that's a very, very important element of what we do. If the person says, no, I want to proceed to trial, then it should be understood that it's unlikely that that person could ever take the stand because they'd convict themselves if they told the truth. But again, they're entitled to the prosecution being required to prove the case beyond a reasonable doubt.
You've mentioned some of the differences between our system and America's. Which has the better system? The Canadian system, from a legal defense point of view, the Canadian system or the American?
Well, they're very similar in structure and they're very similar in nature. They're based upon, the Americans call it the Anglo-American system. We simply call it the British system of justice. And it is, in many ways, a process that operates in a similar fashion. I think that we have embedded within our system a number of aspects that are perhaps fairer to the accused. Since the early 90s, in a really hallmark judgment by Justice Sapinka in the Supreme Court of Canada, a case called Stinchcombe, we have constitutionally mandated disclosure well in advance of making any significant decision.
By disclosure, you mean the prosecution laying out the facts that they have at their disposal so that you understand what their case is based on.
That's right. We know the case to meet, but not only laying it out, we have to get every toxicology report, every pathology report, every photograph that was taken, every SMS message that was intercepted, everything that they have or will rely upon that's relevant to the case has got to be disclosed well in advance. We don't set dates for preliminary hearings or trials before we have full disclosure. And that gives us an opportunity, to, first of all, to either discuss with our client the fact that they're inevitably going to be convicted because the case is so overwhelming, or to provide the opportunity to see what the defense will be. So our system of disclosure, of providing this material, is done well in advance, not near the end of the case, but at the beginning of the case. There can be no ambush, even though in America there's not quite an ambush, but it can be delayed until a point where it's more difficult to make full answer in defense.
Who would you rather defend your case to, a judge or a jury?
I think it depends on the case. Certainly, a lot of cases are based upon highly technical legal arguments as to the admissibility of evidence, and even after the evidence is in, as to whether or not the defense has been, for instance, self-defense is a complex defense. Provocation can be complex. There are certain defenses that have a legal element to it that perhaps in many, many situations are best dealt with by a judge without a jury. You have to remember, a judge has to give reasons. Juries don't give reasons. Juries give a verdict. The reviewability of a jury verdict is much more difficult because all you're basing it upon are the instructions that were given by the trial judge to the jury. So you have to show that those instructions were flawed. When we have a judge alone, they give reasons for judgment. Their reasons have to be sound in law, so that they expose themselves through their reasons as to whether their logic has been flawed, or they've relied upon evidence they ought not to have relied upon, or they've made a significant legal error in terms of the application of the law to the facts.
Let's talk about some of your more high-profile cases over the last almost 50 years of practice. And picking a few is not an easy task because as I said in my introduction, your client list reads like an international who's who. And in fact, there's one case that I would love to ask you about, but I can't because it's in process right now as we speak. Nonetheless, can you, I'll bring up these names. Can you just briefly describe what the charge was, what your defense consisted of, and what the verdict was in each of these cases?
I hope you mentioned a couple I win. I have a couple of wins along the way.
I think you've probably won all of these cases, Brett. In fact, I don't even know if you've lost a case. But let's go through. The first one that I wanted to ask is a lady who is now deceased by the name of Kathy Evelyn Smith.
Kathy Smith was a fascinating character. She was the woman who was charged with the murder of John Belushi, arising out of what was the alleged injection of a speedball at the Chateau Montmartre.
Which is a heroin concoction.
Yes,
basically.
yeah. And she was a Canadian, returned to Canada after an unfortunate interview with the National Enquirer, with a headline indicating, "I killed John Belushi," which was her candid interview with the National Enquirer at that time. She came to Canada. The United States sought her extradition on a murder charge. I acted for her on the resisting the extradition to the United States on a number of levels. At the time, the prosecutor in Los Angeles County was a very conservative prosecutor who only wanted her back to the United States on a murder charge. And we then ran this case up and down the courts for several years. During the course of that, the prosecutor changed to a more liberal Democrat, and all of a sudden negotiations became at least available. And Howard Weitzman, who was now deceased, but our counsel in Los Angeles, who had recently won the DeLorean case back in the early 80s, Howard negotiated a result of an involuntary manslaughter, and once that was done, with a reasonably short period of incarceration, once that was done, we permitted her to return to the United States.
Naomi Campbell, the British
You know,
supermodel.
it's interesting that there are a couple of cases where whenever I have a case of some profile, and particularly, the American media mention my name, they mention it with at least two cases attached to it, Naomi Campbell and Justin Bieber. Two of the least significant criminal charges I've ever been involved in my career. The allegation against Naomi, who's a charming, charming woman, absolutely charming, was a simple assault, as was Justin Bieber's case. And the results were absolute discharges, which in Canada is a disposition where there isn't a criminal conviction. There is an acceptance of responsibility, but there is no criminal record that results from it. And both of them had that disposition in their cases. Having said that, it's interesting that my legacy will be two common assault cases.
Here's a relatively tragic case, I think. Rob Ramage, who was a well-known NHL hockey player. Take the story from there.
Well, Rob and his best friend, Keith Magnuson, who they were here for a funeral relating to the head of the NHL Alumni Association, and they were president and vice president of that Alumni Association. Leaving the wake after the funeral, there was an accident in which Keith Magnuson was killed, and
I'm sorry to interject, but Keith was at one point the captain of the Chicago Blackhawks, was a very high-profile player, certainly in Chicago.
Yeah, both of them. Rob with the St. Louis Blues, and Keith with the Chicago Blackhawks, and both wonderful people, wonderful, and very close friends, and their families were very, very close. A blood alcohol. There wasn't a test because he was severely injured, but a blood alcohol sample taken at the hospital led to charges of criminal negligence causing death and dangerous driving causing death against Rob. The case represented a very, very important conflict between science and human observation. There were literally scores of people who attended the reception after the funeral, who spoke with Rob, said he was perfectly sober, didn't in any way demonstrate any signs of impairment, and was verbal and was engaged, and these were all reputable people and people who took the stand at the trial to say, I saw him, I observed him, he demonstrated no signs of impairment. And it was a case, and it was a judge-alone case without a jury. It was a judge-alone case in which the verdict was a guilty verdict based upon the blood alcohol sample and not based upon anything other than that.
Was that a fair verdict?
Certainly, let me say, we did review it in the Court of Appeal, and it was upheld by the Court of Appeal. Can I disagree with the verdict? I disagree with the verdict. I thought the outcome was not the one that not only I would have wished for, but I thought that there was a reasonable doubt. But nevertheless, that was the verdict.
Kevin O'Leary, who our audience would know as the self-styled Canadian tycoon who's on the Shark Tank and Dragon's Den TV series. Tell us about that case.
Well, it wasn't Kevin's case. It was Kevin's wife's case, Linda O'Leary. Kevin was a passenger on a boat and in the Muskoka area on Lake Joseph in the Muskokas and
just
cottage,
north of Toronto.
North of Toronto, cottage country. They were coming back from a dinner party to their own cottage when they came into contact with a boat and two people were killed in that boat. This is a charge that ought never to have been laid. To this day, shocking that it was. It was, in my view, the recommendation of the police should not have been to charge, and in fact, the then process by which the matter was vetted by the prosecution, I think, was flawed because, in my view, there was never a reasonable prospect of conviction. Linda O'Leary hit a boat that was sitting in the middle of a lake without any lights. And there was video camera footage that demonstrated that it was a dark night and there were no lights on that boat until after the collision, at which point the lights on the boat that was sitting there came on. Not only did the video cameras demonstrate that, absolutely, but there was other observations by the O'Leary's son and a number of friends that were sitting at the cottage because they were approaching the cottage at the time, and they saw the lights of the other boat come on a good 30 seconds after the collision, after they heard the collision. And that was confirmed by the objective footage from the surveillance cameras. That was not only a tragic accident, if fault is to be ascribed anywhere, it was to the outrageous conduct of people who would sit in the middle of a lake with the lights off, stargazing in order to be able to see the stars more clearly, and it literally couldn't be seen until the boat came into collision with the two boats came into collision.
And Linda was fully acquitted.
Fully acquitted, with very, as a matter of fact, all of the theories, every single factual finding was made in her favor, and every single legal finding was made in her favor. This was not a near win, it was an overwhelming victory.
In all your roughly 45 years of practice, what's the most interesting and rewarding case you've been involved with?
No, I think that I can't isolate one. Obviously, there are some cases that I'm very proud of because a new principle of law was established. So they would be the appellate cases, and appellate law was very much a part of my practice, and arguing cases in the Ontario Court of Appeal and the Supreme Court of Canada. I've probably done 1,000+ appeals during the course of my career, and I'm very pleased that I'm associated with some important principles that have had staying power, that even cases that took place 20 and 25 years ago are still the cases to which my colleagues and I refer when we're looking for the principles. So I'm proud of those cases. I'm proud of my involvement and the fact that I was counsel on those cases. Every time a person is acquitted where the Crown, in fact, has not established its case beyond a reasonable doubt, whether they came close or not close, doesn't matter. If they're acquitted properly, then it's a case to feel strongly about and feel positively about.
You've been named as one of Canada's top 25 lawyers several times during your career.
Not sure top 25 lawyers. I think they called it the 25 most influential, and I probably reject that as being, I wish I was more influential on occasion, but
well, you got the honor, and it's happened more than once.
Right.
You've served on numerous legal profession committees and boards, and as you mentioned, you've had an influence on the law itself in these 45 years. And so did your brother, Eddie Greenspan, who we've mentioned was a very successful defense lawyer who died about 7 or 8 years ago. And you mentioned earlier on your sister Roseanne, who's had a very significant career as a law professor at the University of California. You know, the 3 kids from Niagara Falls, and not a rich or prominent family in Niagara Falls as you were growing up, it's quite a story, and you must be very proud of the influence the 3 of you have had in these last 50 years, roughly.
Well, thank you, and thank you for that characterization. I think that's the nature of our country. Our country is a country of immigrants. That's how we started, and the next generation is meant to succeed in a more profound way than the immigrants that brought the family to Canada. I think that part of what this is about is having a passion. And having a passion for justice, and having a passion for the justice system, and being committed in your life to that passion.
So let me ask the standard closing question on Canada Files. And I ask it to you from sort of a legal point of view. What does being Canadian mean to you?
I hopefully have expressed part of that during the course of our discussion. I think it's a commitment to a progressive democracy. It's a commitment to ensuring that the civil and human rights of our community are protected. It's ensuring that our democracy is strong and vibrant, and I think that is fulfilled very much during in a commitment to the criminal justice system and the proper operation of the administration of justice in Canada.
Excellent answer. Brian, thanks so much for sharing your thoughts with us, and continued success with your career, which I expect will go on for at least another 50 years.
Well, I'm hoping. Thank you.
And thank you for watching. We hope you'll join us again on the next edition of Canada Files.
The preceding program was made possible through the generous support of David and Cheryl Carr, as well as the following donors: Akito Investments Inc., the Browning Watt Foundation, Mary Davey, John and Margaret Deeks, Wendy Deeks, Michael and Mary Ellen Hogan, Ted and Alice Kernahan, Philip B. Lind, the Bruce H. Mitchell Foundation, the North Pine Foundation, Francis and Eleanor Shen, the 63 Foundation, and by the Central Canadian Public Television Association.